Hello and welcome to the new series of Drishti IAS. Today we are going to analyze the important provisions, challenges, steps taken to resolve those challenges, everything with respect to Criminal Procedure Identification Bill of 2022. Without further ado, let me just tell you that for prelims, it's very important that you know the facts. From the perspective of mains examination, GS paper 2 mains examination, and from the perspective of political science optional who have this particular subject as their optional, it's very important for you to walk through this segment with me. Now, the news is that Lok Sabha has passed the Criminal Procedure Identification Bill 2022 with a voice vote. There are certain concerns that are related to this particular bill, which the Home Minister says that he is ready to make any amendments about the valid concerns. Let's move on and know about the provisions. What are the provisions that have been long awaited? What are the provisions that are of concern? Let's look at them. So this particular bill wants to replace the Identification of Prisoners Act 1920. This is a colonial act which has been into the existence even after independence. Not only the Law Commission report of 1980, but also the Malimat Committee of 2003 talked about reforming the criminal justice system, and they targeted this particular act. So the current bill that we are talking about, which has been passed in the Lok Sabha by a voice vote, it will talk about the type of data that may be collected. Okay, it will talk about the persons from whom such data may be collected, and also the authority that may authorize such collection. It has said that a central database will also be provided for, in which all the information will be deposited, so that a seamless connection can be made through different law agencies and efficient justice could be provided. The National Crime Records Bureau will be the central agency to maintain the records, which was established in the year 1986, and it works under the Ministry of Home Affairs. And Crime in India, which is a comprehensive report, Crime in India is brought out by National Crime Records Bureau. So this will be the central agency to maintain the records. Whenever the records will be made for the convict or the person arrested, it will be retained for 75 years, and that's effectively a lifetime. And if a person has been acquitted or the person has been released without trial, the information with respect to him, his database or her database, will be deleted after the magistrate or the court in writing gives it to be so. All right, moving on. Now it allows police and prison authorities to legally collect, store and analyze physical as well as biological samples such as retina scan, iris scan. Also, it proposes the legal collection of behavioral attributes as well. Behavioral attributes such as handwriting, signature. This is under section 53 or section 53A of the CRPC of the convicts. Also, any resistance, if a person resists to give the sample that they are requested for, any resistance will be an offense under section 186 of the IPC, and that is obstructing public servant. This could lead to a jail term of 3 months or a fine of ₹500 or both. So these are preliminary facts that we have to be careful about. If a person who is a convict but is not a convict with respect to women abuse, child abuse, or having a minimum term of prison of less than 7 years, okay, then that person can deny to give any sort of sample that they are requested to under this bill. The person who are convicted under crimes with respect to women, children, and having a sentence minimum of 7 years or above, they have to give. Now there is no choice. They have to give their sample whenever it is requested by them. Okay, certain convicts can refuse. This I already told you. They can refuse to give their biological samples. Moving on. Now, the 1920 Act needs to be just go through by. Why? Because we will understand what is the difference between the two. 1920 Act asked for fingerprints, footprints, impressions and photographs, while the current bill has asked for biological samples as well, iris scan, retina scan, semen, saliva, DNA. Now, DNA technology regulation bill is also there of 2019, which is still pending in the Lok Sabha. It has not been passed yet, but it talks about DNA profiling of the necessary persons Here we are talking about the perpetrators who might be having a DNA profile under which we can be very effective with our justice system. Convicted, or not only convicted but arrested for offences punishable with rigorous imprisonment of 1 year or more. They had to give their footprint impression and photograph. Person ordered to give security for good behavior or maintaining peace also had to do the same. Also, magistrate was the authority. He may order in other cases collection from arrested person to aid criminal investigation. Also, apart from the magistrate, investigating officers, officer in charge of a police station, or of rank sub-inspector or above. Here in the current bill, what will happen? Not if we talk about the magistrate, cosmopolitan magistrate, or the judicial magistrate of the first class is responsible for giving any sort of direction for correcting these samples. Also, with respect to other officers, here like we have them, the officer who is minimum at the level of a head constable or above can also give their command with respect to collecting DNAs. Now, this is one of the concerns because there is a wide range of people who are authorized under the current bill. Let's move forward and talk about what was the need of the entire procedure. Why did we need this bill? Because the Ministry of Home Affairs says, first we have to see that there is an improvement in the conviction rate. Here in India, the conviction rate is very low, and this is the data I am quoting from National Crime Records Bureau report of 2020. Okay, here the conviction means registry of cases. After that, any sort of person who has done that crime to be caught. In layman's term, suppose 10 people are there, out of those 10, 2 have actually committed the crime, and the justice system is able to pinpoint that on them. So this is conviction. So conviction rate is very less in India. Murder cases conviction is only 44%. For rape, it is 39%. For attempted murder, 24%. Robbery, 38%, and 29% in dacoity cases. But in countries such as USA, it is as high as 93%. For Australia, it is even higher. It's 97% of overall conviction. For UK, it is 83%. Canada, 68%. And these are the countries who are champions of human rights. So for that, we need, for becoming a champion of human rights, along with other things, we have to make sure the conviction rates are proper, because then only the human rights will be protected, and that will enthuse the crores of law-abiding citizens. If they do not have, and if they won't have any faith in the justice system, mob lynching and everything else will follow, because we need to make sure that the common man has a faith in the justice system. Then only people will not take laws into their hands, right? Because people need instant gratification, and there is a romanticization of the idea of getting justice, and that is correct. That is the whole premise of living in a democracy. So this is something. Another thing, send a strong message in the society as well. And the next generation crimes are going to be high tech. We cannot just rely on old techniques. That is why a new bill was needed. And the particular technology that will be provided through the help of digital repository, through the help of CCTNS system, this will all work providing as a T for technology under smart, strict and sensitive, modern and mobile, alert and accountable, reliable and responsive, techno-savvy and trained. This bill will provide the T of smart policing in 2014, which was this term was given by Prime Minister himself in 2014. Moving on, if we talk about other government initiatives, the CCTNS system, under which the data with respect to crime records have been stored, and 99% of the police agencies, police system has already been integrated into the CTNS, and integration of the fingerprint database of Central Fingerprint Bureau and NIST fingerprint image software, which is used by the Federal Bureau of Investigation of the USA, has also been done. So these are the certain initiatives. Apart from that, not only this, but forensic universities have been established in the country, many forensic universities, for having a proper knowledge about the increase in crime rates with respect to newer technologies, right? Other than that, a modus operandi has been set up under Ministry of Home Affairs, which will provide the crime trends and it will suggest the state police with respect to how to work according to these crime trends, as well as IPC and CRPC. They are also undergoing through reforms. They will be reformed eventually. So this entire thing cannot be seen in isolation but holistically. Let's move forward and of course talk about the issues, the concerns with respect to the particular bill. So it is saying on the parameters of fundamental rights under right to equality, Article 14, 19 and 20 clause 3 as well as 21. Everything is this, these are the said articles that are being violated. 20 clause 3 in fact says that a person cannot be a witness against himself or herself in the case. And here the problem is, the provision of the bill says that if a person does not give the sample, the biological samples of himself or herself, it will be an offense under section 186 of the IPC. That is the first problem. Right to life and liberty, right to privacy, which was stated in the Justice Puttaswamy case of 2017, that is also being infringed. So you can see on many parameters the bill will not go through by. Okay, so this is being said that if any person will give his or her biological sample, it can happen that narco analysis and brain mapping could be done, while the Ministry of Home Affairs says that no, this won't happen without the consent. But who knows? Then human rights provision as laid out in the UN Charter with respect to the implied forcible taking of samples, which is hurtful to the dignity of a human being, survivor or victim or perpetrator. So that is also something. Implied use of force in clause 6, 1, to take measurements violates the rights of prison. That was stated in the 𝐃𝐫𝐢𝐬𝐬𝐻𝐿 case. Supreme Court said that. Also the 𝐶𝐞𝐵𝐢𝐬𝐻𝐿 of 1964, Charles Sobraj of 1978, Sheila Barse, Pramod Kumar Saxena 2008. So for prelims it could be like 𝐶𝐞𝐵𝐢𝐬𝐻𝐿 case of 1964 relates to which of the following. So different options could be given, under which you have to make sure that it's related to prisoners, it's related to the profiling of prisoners. Okay, as in India right now, the data protection bill is still a bill. There is no foolproof mechanism of saving the data. How will it go by if the data with respect to so many people, because not one thing, let me tell you, not only the convict but the arrested as well as the person who are giving help in the aid, person who are protesting, their biological samples and behavioral samples can also be collected. So that can happen that a person who has been framed, person who has been arrested, not on any proper premises, their data is still out. What will happen if somebody who is not authorized to get access to that data gets it? And that is a problem with cyber attacks in the times of war. Like right now we are seeing how cyber crimes have increased. This cyber warfare can be used by, let's say, China, let's say Pakistan against India. So these are certain concerns. So what should be done? First, as the opposition says that this is a bill that will have far-reaching impacts, it shall be referred to the Parliamentary Standing Committee, which must happen because we need thorough deliberation. Anything shouldn't be just passed on like wind without any proper deliberation. First, that if the bill has certain issues that have to be looked at by the ruling party, that should be looked at. Also, we need to delineate the needs properly. Where and when do we need the data and where do we not need the data? That should be delineated properly, because there is a provision of having the data, biological sample from other persons. So other persons is a very open-ended term. We do not know who is other person, who is not. So it will be very open to interpretation. So we need to have a proper line to be demarcation, line for demarcation. foolproof data protection mechanism. It is of course said by the Ministry of Home Affairs that there is a mechanism. There is a very less chance of data proliferating from the central repository, but for that we need to have an act, so that if anything of such might happen, but we do not have any legal authority to challenge it in the court, that's a loss. Transparency and accountability should be set. Proper CCTVs should be installed in those rooms from where biological samples are being collected, so that it can be made very informative for transparency and accountability as well. Then there should be a grievance committee at every district level, so that if there is a person who is aggrieved with respect to the entire process, can reach there. Okay, so these are the certain initiatives that the government can take. The question goes like, critically analyze the criminal procedure identification bill of 2022. So that's it for today. Tomorrow we shall meet again with another segment. Until then, stay updated, and thank you so much for watching.